Right, I just realized that I hadn't connected my audio. Um, this is time for you to raise any questions that you might have, since on matters that we have covered, matters you came across since we last met. Um, there was a demand that we should go to looking at Chapter 8 on human rights today, in order that they may facilitate your early start working on the assignment. The assignment, of course, is the focus is on the legal effect and also court the decisions on Article 39 in the context of how the protection of human rights given or accorded by the International Covenant on Civil and Political Rights works in Hong Kong, of course, in the context of the Basic Law. And that's why we will be looking at that chapter. And let me see, we have 38 of you who have logged on. The slide that I'm showing you now I don't. Could you either ask that question again? Because would you mind telling me? I'm not quite sure what I'm afraid I don't understand what the message was. Chen Hongman, can you be more specific? I welcome you speak up. Actually, I mean, it's very difficult to, and it's not efficient if you only communicate through this chat box. Can I enable your mic? Yeah, which I have now, Jahanman. Can you say what you wanted to say? Now, I want to ask again if you might have any questions. Now, it's usually at this stage, or actually a bit later, we do a bit of review to see what we have studied so far. and just reminding us how what are the how you will be assessed for the purpose of this course. So what we have done so far, among the 8 major topics, we have done 6, and up to the role of courts, including judicial review. That's what we did up to last lesson. Now what we have remaining, 3 lessons, and it will be for us to cover chapters 7 and 8, and with the request that we had last lesson that we should start looking at chapter 8 in order to facilitate your early start on the assignment question. And having looked at the 2 topics, I think we could swap it, so that we can do or swap the 2, 7 and 8, so that 8 becomes 7. And just a summary, the intended what we call intended learning outcomes, we look at how the legal relationship between Hong Kong and PRC post 1997 under one country, 2 systems. Of course, you will understand when I make reference to PRC here, it is PRC as the mainland, or as People's Republic of China without Hong Kong, conceptually without Hong Kong, and that's and yet Hong Kong is part of PRC, right? So I wanted you to be absolutely clear conceptually. Under one country, 2 systems. The one country is PRC. The 2 systems refer to the socialist system as being practiced in PRC, except Hong Kong. And Hong Kong is the other system in this one country, 2 systems, under which the capitalistic system before July 1997 is being maintained, and therefore when we are looking at the legal relationship, is this legal relationship in that context? Are we already there? And second point is we have learned, and the relationship between Hong Kong basic law and the Hong Kong and mainland legal systems. Now, conceptually again, there are the 2 systems. One is Hong Kong system, the other being the mainland legal system. And then Hong Kong basic law sits on the 2 systems. On the mainland, and Hong Kong SAR, because it's a piece of national law. National law. Who made that? Which institution made the law? Do you remember? Which institution made the Hong Kong basic law? Yes, I think it is. Yes, the answer came now. It's MPC, right? So, in our context, we are not sort of trying to be pedantic or trying to sort of play around with words, but we do have to be precise, right? So when one makes reference to China, or PRC for that matter, we should be specific. Just like in practical terms, when a country is imposing sanction on, or trade sanction rather, on the China without saying anything more, then that sanction, legally speaking, would cover Hong Kong, because Hong Kong is part of China. Right? So this but in international trade and international relationship, Hong Kong does have a rather unique position. Sometimes it's being considered as part of Hong Kong, part of PRC. Sometimes even being recognized as part of PRC, it enjoys a status independent of the PRC. So that is something what makes Hong Kong unique. And back to what our course here, it is a concept that you have to master correctly, and that is the position or the status of Hong Kong Basic Law in the context of the relationship of the Hong Kong and mainland legal systems. Third point is you should be able to identify and discuss key sections or important sections of Hong Kong Basic Law with regard to the executive, the legislative, and judiciary branches of Hong Kong government. Now, this is where a lot of students may ask and say, do we have to remember them? Well, my usual answer is, first of all, there aren't that many, and if not knowing, not remember, not, and we are not running a memory test. So, but it is the if you should know some of the key provisions, not necessarily word for word, but the important parts. I mean, you should know, for example, when it comes to the legislative branch, you will know, you have to know Article 66 creates the Legislative Council as the legislature. You will have to know Article 73 set out the powers and functions of the Legislative Council. For the Chief Executive, his powers and functions are set out in Article 48, and his powers that counter-check or counterbalancing the legislature are found in a few articles. Articles 50, 51, 52, Article 74, Article 75. Those are articles that you ought to know. And then, of course, the judiciary. And so I'm not going to mention all, but you can, there aren't that many, as I said. The entire basic law, Hong Kong Basic Law, consists of how many articles? How many articles are there? The Hong Kong Basic Law? Yes, that's right, 160, with the annexes 1, 2, and 3, right? So that's the basic law. Fourthly, and this is where we are right now, the framework for protecting fundamental rights under Hong Kong Basic Law. We were looking at judicial review more in the context of the role of the judiciary, but actually it does also contain, involve part of the protection of how human fundamental rights are protected under the basic law. And the courts, of course, through judicial review, is given, have the power to review the exercise of powers by the executive. All right. And for the purpose of this, I had given you this before. So we have 25% of the final mark will come from your assignment. It's an essay question. Now you've seen it already, and you have to write an answer with a maximum of 2,000 words. Then you will have examination, and at which you are required to answer 3 short questions out of 5, and at the same time answer 1 long question out of 2. And usually these are essay type questions. Possible there might be question problem type, but in most cases it will be essay type question. I saw that a few of you are just coming in. So any questions from what I've covered tonight so far? No? Good. Right. Protecting human rights. This is your chapter 8. Courts protect human rights. Well, of course, they are not coming out, physically. It's the institution itself. It's the institution. And I had put on the slide that you should read extract 1 in chapter 6. This is our former Chief Justice. In fact, now there will be 2 former CJs. So this was taken from our first CJ, Andrew Lee, and there from one of his many speeches, we extracted this for you to read about how he described the judiciary as performing a function of protecting human rights. And of course, the context, as I had said last time, this is really in the context of acting as an independent adjudicatory body to form an opinion as to whether whoever alleged or whoever purported to exercise a power given by the law had exercised the power within the limits or within the parameters set by the when is exam? Can anybody answer that? I do not have the date on at my fingertip. I think you will have to check. It will be sometime, quite far ahead actually, from what I know. Yeah. So I think it's all there, but I don't have it. As I said, I do not have it at my fingertip. So the courts. This is it's important in our common law system where the rule of law is our cornerstone, and this is where the courts play their role in scrutinizing or examining whether powers exercised by the executive and sometimes the legislature had gone outside of the law, right? And it is difficult for courts to protect human rights without constitutional documents on human rights. Well, I had asked why. I don't know whether you could think why. You could offer an answer to this question of why it would be difficult for the courts to protect human rights if there wasn't a constitutional document. What do you think? Why is that? Not enforceable. What do you mean by enforceable, Alice? Not constitution. No, actually I was asking what the meaning of enforceable in this context, in the context that you wrote, Alice, because you were answering the question, why would it be difficult for the court to protect human rights without constitutional documents on human rights? And you said not enforceable. But now you say not constitution. What again? I mean, what do you mean? Now, can you help me, Alice? I think all these questions about Jiahongman, I mean, let's focus on what we are discussing right now. All right. The ordinances seldom protect human rights. There is also no ground to judge if a law contravenes with the principle of human rights protection. Yes, I think we are coming close to that. I think we are coming close to it. Yes, you're very good. This is good. To start with, constitutional documents. This is almost a norm, a common feature of the content of constitutions. We have mentioned this before, and that is for a constitution, normally we're talking about the division of powers, how the power to govern will be allocated to various institutions within either the country or normally a country, and then within that constitutional document, within the constitution, there will be, and then as I said, there's a norm, there's a section on the protection of human rights, and these will be set out in writing in the constitution, and in the context of what Leung Kam-soon said, this is where you will find a benchmark, you will find the standard, you will find the principle, and all these will becomes a tool, if you like, in practical terms, that the courts may use to protect human rights. And of course, under our fundamental, under our basic principle in the common law system, that all laws, all written laws, including the Constitution, are subject to the interpretation of the judiciary. Right? What effect what legal effect or what practical effect does a constitution have, or rather does a provision in the constitution have, is for the courts to give it the meaning through interpretation. So this is the common law system, and that's why, with that it will, without that it will be more difficult, right? It is, and don't forget, a court is in a common law system. It is an adjudicating body, and it performs the function of resolving disputes, including disputes between government and the people, and looking at cases, again, in practical terms, in Hong Kong or in common law system, judicial review cases, right? And under judicial review, the courts have jurisdiction to issue orders of that quashes decisions, orders that mandate or compel the public body to implement certain measures, to do certain acts, or to issue an injunction forbidding the government from doing certain acts. So that deals with this question. Do you understand what I was talking about? No. So conceptually, and in Hong Kong, and as I had explained, the basic law itself is a constitutional document. And for the purpose of protecting human rights, indeed, we have to, in the case of Hong Kong, look at three very important documents. And these are: 1. The Hong Kong Basic Law, made by the NPC in April 1990 and commenced operation on July 1st, 1997. Then the next one is Hong Kong Bill of Rights Ordinance. You are given the extract of the ordinance as Appendix 2, to Chapter 8. Appendix 2 to Chapter 8. On the version of the manual that I have, it runs from page 105 to page 117. I think you'll find that. And then the next document is ICCPR, International Covenant on Civil and Political Rights. And that also is given to you as Appendix 3 to Chapter 8. Appendix 3 to Chapter 8. We haven't included the entire covenant here. We have articles, we start from the preamble and then all the way to Article 27. Content of 2 and 3 are mostly the same. They are not identical, but they are very, very similar. And the question here is, what is the important difference between legal status of 2 and 3? Alice? Yes, I saw that. Thank you. ICESCR, we are looking at, of course, economic and social rights. That, of course, it's not really, well, it's an important area, but our focus is more on the fundamental rights. Now, fundamental rights, we are talking about generally freedom of expression, freedom of association, freedom of movement, freedom to life, to life, and freedom, equality before the law, and so on. Now we'll be looking at those rather than looking at, for example, right to education and other economic rights right? So this is the question: what is the important difference between legal status of 2 and 3? I think you know the answer. Please try. Yes, the legal status of Hong Kong Bill of Rights Ordinance against the legal status of International Covenant on Civil and Political Rights. That's the nature of these two documents. Park Sing is right. But and so, therefore, what's the difference in legal status? Good. BOR borrow can refer to cap. What do you mean by can refer? What do you mean by can refer? I had asked this question. Asked Alice this question. What does it? What do you mean by enforceable? Enforceable meaning what? Now this is an important concept. Again, a common law concept. A law is enforceable. What sort of concept are we talking about? Well, enforceable. It is, if you want to describe it, the effect of it is you can use that as a basis to claim your rights, and if the court agrees, then the court will exercise its power to make an order in your favor. So if your right allegedly been impinged by a certain administrative decision, the court then can then make an order to quash that decision. Now, so the concept of enforceability, the concept of enforcement, is requires the involvement of the courts to make the appropriate orders, and these orders will be carried out or will have to be complied with. Now, it is where a non-compliance with a court order which will attract the the offense or the crime of a contempt of court. Now, if one is found to be guilty of a contempt of court, the court may exercise its power to punish. Well, the punishment can be a fine or an imprisonment, or imprisonment. So this is the enforceability or being enforced. The concept, what the concept of enforcement is. Now, back to my question here. International treaty and localized law, yes, in passing. How do you apply this to the question asking about legal status of 2 and 3? Does ICCPR have any legal status in Hong Kong, in the Hong Kong legal system? No. Yes, that's correct. And the ordinance? I think you know the answer. The answer is yes, right? The ordinance was a piece of written law passed by the Legislative Council back in 1991. And because of Article 8 and Article 160 of the Hong Kong Basic Law, that ordinance was being maintained as part of the Hong Kong, or part of the law of the Hong Kong Special Administrative Region, except for Section 3 of the ordinance, which was decided by the Standing Committee of the National People's Congress back in February 1997, because it was considered that provision contravenes the Basic Law. If you turn to page 105 of your manual, you will see what that section says. Section 2.3. If I can read that to you. I hope you have access to the manual. Do you not? Do you have do you have the copy of the manual with you? That's good. Now that section says, in interpreting and applying this ordinance, regard shall be had to the fact that the purpose of this ordinance is to provide for the incorporation into the law of Hong Kong of provisions of the International Covenant on Civil and Political Rights as applied to Hong Kong, and for ancillary and connected matters. So this provision appears as a direction, an order giving to the judges, so that when they interpret the law, the ordinance, they will have to give effect. Now, the word is shall be had. Shall be is compulsory, so they must give effect to the they must have regard to the fact that this law, Hong Kong Bill of Rights Ordinance, is to incorporate the ICCPR as applied to Hong Kong. Now, it's a bit circular, is a bit circular, but the effect is to have the court when interpreting a statute in Hong Kong, making sure that will be reflected. So what it actually says then is in reflected more specifically over the page, section 3. If you turn to section 3, what it says is this: all pre-existing legislation that admits of a construction consistent with all this ordinance shall be given such a construction. Alright. And section 3.2 says all pre-existing legislation that does not admit of a construction consistent with this ordinance is, to the extent of the consistency, repealed. Now, the word construction, you see here, means interpretation. Well, practically has the same meaning as interpretation. So you can see it with section 3 in the Human Rights Ordinance. You will see that it has an impact, therefore, on all pre-existing legislation. The word pre-existing means, if you turn to section 2, means legislation enacted before the commencement date. Before the commencement date. And the commencement date of this ordinance was 8th of June 1991. 8th of June 1991. You find that date set out in section 2 of this ordinance. So very importantly, and let me complete it. Section 4 then goes on to say all legislation enacted on or after the commencement date shall, to the extent that it admits of such a construction, be construed so as to be consistent with the International Covenant on Civil and Political Rights as applied to Hong Kong. What it basically says is, from then on, from 6th of June 1991 onwards, all the laws that were effective, effective before then, will have to be interpreted in a particular manner. That particular manner is regard has to be to give regard to this ordinance, which is for incorporating the ICCPR in Hong Kong. And when you interpret these laws, you must try. You have to interpret them in such a manner that the meaning is consistent with the Hong Kong Bill of Rights and ICCPR. If any ordinance has the problem of not able to be interpreted in such a manner consistent with ICCPR, they are taken to be repealed. Now, this is a prospective repeal, and it set out a very, if you like, such a provision have been criticized as allowing the courts to perform the function of the legislature indirectly. Why? Because first of all, the power to repeal an ordinance under either common law or the Hong Kong Basic Law, it has to be with the legislature. Right? Because the legislature is the only lawmaking body. However, this provision, which indirectly gives the court that function, because as long as the court find it not possible to interpret a certain ordinance consistent with the ICCPR, then that law is taken to be repealed. Repeal? Yes. So, instead of the legislature repealing the law, it becomes the court repealing the law. So that on that front, on that basis, well, one of the bases, Section 3 cannot be considered as in conformity with the basic law, and therefore the Standing Committee of the NPC decided not to adopt that part of the law. And the rest of the ordinance, though, was specifically adopted. So that is what happened. Okay. Any questions? Next, we want to look at the question of what is the ICCPR. It's an international treaty. When you go to UN, you see it. You see that international. This is different from the from other international human rights treaties. You have, which include, for example, the European Convention on Human Rights. This one is more global. It's an international treaty with details of basic standards of civil and political rights. For example, freedom of expression, freedom of assembly, the right to vote, and so on. And it was signed and ratified by most countries. This is an international treaty, and the normal procedure for a country to abide by that is, first of all, the government representatives or those who represent the country may sign the treaty first, and then subject to ratification. This is another procedure which then makes it clear that the states party will start having effect on the state party. Like PRC being as an example, it has signed the treaty in 1998, but it has yet to ratify. So if it hasn't been ratified, then the treaty does not bite yet. There are many conditions that have to be satisfied before a state party can ratify the ICCPR. For example, they have to satisfy the country, the PRC, for example, in this case, we have to satisfy the ICCPR body that all the laws in force in mainland China comply with the international human rights standards. I think this is, probably one of the difficulties that, or one of the reasons why it's taken some time, and China is yet to ratify. As well, history is the first document protecting human rights in Hong Kong. Now, we have to be careful here. The concept is, the legal situation is that because we are a common law legal system that we don't really need an international treaty for the protection of human rights. Common law itself has, within common law, fundamental rights are being protected. You don't really have to go to the treaty, and under common law, international protect these human rights can be enforced again through the courts. As far as Hong Kong is concerned, we have this year 1976, which is important, and it was the year when United Kingdom, herself a member state of ICCPR, extended the covenant to apply to Hong Kong, with certain reservations, with certain exceptions, exceptions such as exception regarding universal suffrage, exceptions regarding immigration matters. These are accepted. And under Article 39(1) of the Hong Kong Basic Law, most of the ICCPR provisions still apply to Hong Kong. Well, we'll be looking at 39(1) more closely later. But let's deal with some fundamental concepts first. What is the Bill of Rights? What is the Bill of Rights? Now, if you turn to page 107 of your menu, 107, and you see Part 2, the Hong Kong Bill of Rights. You see that? This is where Hong Kong borrowed this expression. Is it 103? Let me see, 103. Because my version is right. In any event, it should be the extract of is Appendix 2. Appendix 2. My version is maybe yours. Let me see. My version. Mine is dated. I don't have a date here, but yeah, they may have made some editorial rearrangements. It doesn't matter. Okay, good. Part 2, the Hong Kong Bill of Rights. Now, Bill of Rights is when we refer to it, when we use this expression, this name, without more, it is generally understood to be a legal instrument that deals with some fundamental rights, or sometimes we call human rights. For example, in UK, when you say Bill of Rights, then the first thing that come to mind, maybe for those who know this area of the law, will have the first thing that come to mind may be Bill of Rights 1689, which is but in Hong Kong we have this defined, and you will see that on Section 2, in Section 2 of the Hong Kong Bill of Rights Ordinance, there is an expression Bill of Rights, which is defined to mean the Hong Kong Bill of Rights set out in Part 2. So, by way of enactment, by way of a local law, it's given a Bill of Rights in Hong Kong. But what is the content of it? What is the content of it? The content is mostly copied from the ICCPR. And unlike ICCPR, Bill of Rights is law easily enforceable in courts. One of the reasons is that because of the similarity in wording between the Bill of Rights Hong Kong and ICCPR, the courts have held that the Bill of Rights also entrenched by Article 39(1) of the Basic Law. Now, this requires a little bit of explanation. You will have to look at the wording of Article 39. The wording of Article 39, and which you should turn to Article 39 in your menu, in your reference material, and it says, the provisions of the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, and International Labour Conventions as applied to Hong Kong shall remain in force and shall be implemented through the laws of the Hong Kong SAR. Now, the important reference, the important phrase is as applied to Hong Kong. As applied to Hong Kong. So this, of course, we are referring to the time frame of 1st of July, right, 1997, because and then it says shall remain in force, so continue to have in force, and shall be implemented through the laws of Hong Kong. Now, because of the similarity of the ICCPR with the Hong Kong Bill of Rights Ordinance, you can almost read Article 39 as saying that the shall remain in force means forever, and means the word entrenched. It means protected, means cannot be changed. You remember I mentioned about amendment of the Basic Law. It's not easy. It requires very complicated steps. The authority to amend, of course, lies with the National People's Congress, and we look at Article 159 of the Basic Law, and only the National People's and only the Standing Committee can move a motion to amend, or the State Council, or if the motion is to be initiated from Hong Kong, then you need to have the CE. You need to have 2/3 of the Legislative Council members, 2/3 of the National People's Congress delegates, all agreeing to the proposal to amend before the proposal can even be taken to National People's Congress. So it is another way. It's a means to keep the provisions of the Basic Law more permanent, more stable, and not so easily amendable. And the effect will therefore take Article 39, as I have read it to you, will remain in the present form for very long time, or because the procedure for changing that, for amend that, is too complex. I make reference to the case of W against Registrar of Marriages only to show you this is where such reference was made. Such remarks were made by the Court of Final Appeal. And simply for illustration purpose, we can look at Article 19 of the ICCPR, and indeed we have given you the version of ICCPR. Article 19 ICCPR, and it is, well, I know my version of the manual may not have the same page number, but Article 19 on mine is page 129, and it reads, everyone shall have the right to hold opinions without interference. Secondly, everyone shall have the right to freedom of expression. This right shall include freedom to speak, freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontier, either orally, in writing, or in print, in the form of art, or through any other media of his choice. Now, you will see that this provision basically is reflected and seem to be identical to in Article 16, excuse me, of Hong Kong Bill of Rights Ordinance, of Hong Kong Bill of Rights, which is in Part 2 of the Hong Kong Bill of Rights Ordinance. The reason why the numbering is different is because there are certain provisions at the beginning of the ICCPR that only apply to member states, to a member of ICCPR, which is a country or a state. And Hong Kong being what it is, because it doesn't have a sovereign, it's not a sovereign power, therefore those provisions cannot apply. So I'm not going to read this aloud, but you just turn to your manual and then compare to two articles. You want to do that? Are you all right? Now, maybe all right. Maybe it's good time. Maybe I will take a 10-minute break. All right. I want you to make use of this time to look at the text of the two, the text of ICCPR and the text of the Hong Kong Bill of Rights Ordinance, Part 2. Right, let's resume. I saw the question, Mr. Jiang, and Wu Jiayi, thanks for responding to that. Yeah, I think you're absolutely right. Let's focus on the topic, on the subject at the moment, and indeed don't actually you won't be able to answer the question well unless you understand the topic as a whole, right? So that's my advice. But and be patient, because we're going to get there very, very soon. All right. this chapter is on human rights, and it's just normal that when we think about when we talk about human rights, one goes to Iccpr very quickly, immediately, and because of the history of Hong Kong, and because of in the sense that 1997 people are worried, and indeed people are even more worried that in 1989 because of what happened in China, June 4th, and so that led to the an enactment of the Hong Kong Bill of Rights Ordinance. And at the same time, actually, in the documentary and in the constitutional document, the letters patent, the British government, the UK government, also indeed enacted a provision which is quite similar, which has similar effect as Article 39. Indeed, it basically, and also a very closely, not closely, but nearly the same effect as what I had read you, sections 3 and 4 of the Hong Kong Bill of Rights Ordinance, i.e., it has a status in short above or prevail over other ordinances, and so it becomes constitutional. And that's why we brought in Iccpr at the early part of this chapter, and also Article 39, and also Hong Kong Bill of Rights Ordinance. So that's the reason why Article 39 of the Basic Law is so important. And indeed, and once we have dealt with that, we have to come back to the Basic Law, and we'll have to tell you that, well, actually the Basic Law the provisions in the Basic Law that protects human rights is not confined to, is not restricted to, is not only Article 39, but there are other provisions. And indeed, we have the entire chapter of the Basic Law on the protection of fundamental rights, chapter 3, and also scattered in some of the other articles which protects rights that may be categorized as human rights. So this is one very special feature of the Hong Kong Basic Law as a constitutional document. You can feel and you can see it actually has placed not emphasis, but at least had shown the importance of the protection of human rights. Why? Well, looking back history, I think it was at that time the enactment of the Basic Law by the National People's Congress. One of the political tasks, aim, was to give confidence to Hong Kong people at the time about this handover in '97. There was at that time the sort of confidence crisis. So it was, and as a matter of fact, there have been some significant number of people emigrating to other places. So this is one of the means to give people confidence about 1997. So first point on this slide is to say that there are actually many articles in the Hong Kong Basic Law that protects human rights, and we have the whole chapter on human rights or fundamental rights, and that is chapter 3. And most important within the chapter is Article 39(1), which continues to apply most part of Iccpr to Hong Kong, and it also protects the Bill of Rights. And I already explained how it protects Bill of Rights, which has become entrenched. Particularly, Article 39, for our purpose, often comes up in exam, and of course now the assignment question. And so don't forget there are other important articles. And let's go through some of these. Let's go through some of these important articles. Article 4. The Hong Kong Special Administrative Region shall safeguard the rights and freedoms of the residents of Hong Kong SAR and of other persons in the region in accordance with law. So this Article 4 is found in the general principles. It is set out in general terms, in principled term, and as you can see at the note there, in constitutions, they normally will provide they will normally protect their own people. It's our people and that sort of thing. But here, it was made clear that not only residents of Hong Kong, but other people, other persons in the region, as i.e. SAR, Hong Kong SAR, is safeguarded. Their rights and freedom are safeguarded. Got it? Yeah. There's a twist here. When you read these articles, when you get to the end, if it says in accordance with law, this will be an expression which shows you that the basic law itself doesn't provide the protection directly, but the protection has to be done in accordance with law. So there has to be certain law there for enforcement, for providing the basis of enforcement or making complaints. The next is about the right to property. Right to property, again, this is an area where many people had worried because under the mainland system, which is a socialist system against Hong Kong's system, which is capitalistic, the right to property seem to have a different ideology basis. On the mainland, it was, at least in the early 90s then, it was still much less emphasis was put on individuals' right to property, because the system on the mainland then, as far as property ownership is concerned, is mainly communal property. In Hong Kong, we are talking about a capitalistic system. Individuals' rights are well protected, so how is it then when it comes to providing this protection in the basic law? What was the approach? First of all, it's under Article 6, where it's made, again in general terms, that Hong Kong SAR shall protect the right of private ownership of property, in accordance with law. Right? That's Article 6. And in Article 105, this is one which also has actually attracted some litigation against government. The provision reads as follows. It says, the Hong Kong SAR shall, in accordance with law, protect the right of individuals and legal persons to the acquisition, use, disposal, and inheritance of property, and their right to compensation for lawful deprivation of their property. The focus has been on the lawful deprivation. The the Chinese expression is 经用. So it doesn't. Well, first of all, 经用 means government for public purposes decided to 经用, to take over a certain piece of land, and in the realm of human rights, we usually use the word deprivation, depriving you the right to your land. And of course, for the Basic Law 1051, it is addressing or looking at lawful deprivation. So there might be deprivation which is not lawful, then that's outside. Lawful means it will have the sanction of the law. Now, if that should happen, then Article 105 provides that there will be a right to compensation. A right to compensation. Now, this is how a property ownership is protected, because if this is applied in relation to land, then you will see that actually Article 7 of the Basic Law makes it clear, and therefore, as sometimes people worry, that it says the land and natural resources within the Hong Kong SAR shall be state property. State property. And the government of Hong Kong SAR region, Hong Kong SAR, shall be responsible for their management, use, development, and for their lease or grant to individuals, legal persons, or organizations for use or development. The revenues derived therefrom shall be exclusively at the disposal of the government of the region. Land property belong to the state, and everyone who says I own the land doesn't really have the ownership of the land in law, but only is a grantee or a lessee of the land in question. So that is Article 6, 10, and 105, which are important on individuals or companies' right to property, and indeed you will see, and you must understand, there's no absolute right. It's not absolute right. You can't sort of prevent government from 经用the land, as long as it's for public purpose, and compensation is paid. And we can go to Chapter 3 now. Chapter 3's title is Fundamental Rights and Duties of the Residents. And most articles protecting human rights are found in this chapter. It begins in Article 24 by defining who is Hong Kong resident, i.e. who is entitled to the ID card. And we had looked at the case of Ngarling and how Article 22 and 24 were interpreted by the Court of Final Appeal. That is in relation to the judicial review proceedings. But protection of human rights, it is also important and relevant, because when we talk about protection of human rights, which human rights belong to whom that should be protected. In Hong Kong, as I had shown to you in the general provision, the general principles in the Basic Law, everyone basically, whether you are a resident or not a resident, but physically in Hong Kong, you are entitled to most of the rights. There is also a clear provision, which is not unusual, but which every so often people forget, and that is Article 42, which says Hong Kong residents and other persons in Hong Kong shall have the obligation to abide by the laws in force in the Hong Kong Special Administrative Region. So the question is, what kind of obligation are we talking about? This is my last bullet and the question there. That duty. What duty is it? Or what obligation is it? Somebody? I just read it actually, but can you answer that question? What is it? What is that duty or what is that obligation? Yeah, not to break the law. Yes, to abide by the law. Abide by the law, not to break the law. That's right. So, of course, this provision is different from other provisions in the statute you normally find. Right? This states a principle. You cannot punish somebody by saying, oh, you contravene Article 42 because you did not abide by law. No, then actually it provides a message, first of all, to everybody, Hong Kong, be a Hong Konger or a non-Hong Konger, but a resident or a visitor. Everybody here in Hong Kong has to follow the law, and that's it. And if you are not, then under the general law, action may be taken against you under the general law, mostly the criminal law. Yes? Okay there? Are we okay there? Right, let's look at some of the more important rights in the Chapter 3. Article 26. We refer to Hong Kong permanent residents having the right to vote and stand for election. A right to vote and the right to stand for election. Again, I didn't have the entire provision quoted in full, but at the tail end of this, it says, in accordance with law. In accordance with law. So there is an obligation of Hong Kong SAR to enact such a law to give effect to a Hong Kong permanent resident's right to vote and stand for election. And under Article 44 and 67, you will see the right to stand for election in the case of Hong Kong, both in relation to the Chief Executive Office and electoral seats. There is a restriction to the candidates. That restriction is that they must be Chinese and with no right to live overseas. But there's an exception, of course. I mean, I think I mentioned that to you. There's Article 67, and under the Legislative Council Ordinance, there are seats in LegCo which may be taken up by people who have a right of a vote in a place other than Hong Kong. So that is something again very much unique to Hong Kong, where a sort of foreigner can actually take part in the elections to the lawmaking body. So 20% of the seats can be taken up by people holding foreign passports. Article 26 says permanent residents of Hong Kong, that's what I read to you earlier, shall have right to vote and the right to stand for election in accordance with law. Now, in accordance with law, in this context, when you read it more carefully, just like my third bullet point, It's suggesting to you that you can, what can happen is a law may be enacted to restrict the right to stand for election or for election generally. That's why I kept one of the reminders. When you read the basic law, you have to be thorough and focus or pay attention to expressions like in accordance with law. When you start with something very grand, something that, oh, you can do this and do that in accordance with law, at the end, that means that there may be restrictions because that right can only be exercised in accordance with law. All right. So that's the right to vote and stand for election. And let's look at how these rights, how other rights though are expressed. Pick out Article 27 and you can look at the questions. Does this article provide enough detail on the meaning of these 9 rights? There are 9 rights. What are they? Hong Kong residents shall have freedom of speech, freedom of the press, and freedom of publication, freedom of association, freedom of assembly, freedom of possession and of demonstration, and the right and freedom to form and join trade unions and to strike. The question is, does this article provide enough detail on the meaning of these 9 rights? Does it or does it not? Or does it matter? Yeah, right. Yeah, not so detailed. For the champions of the human rights, of course, the ideal is to have all these articles have the various facets and of this right set out in clear terms. But conceptually, this may not be may very well not be the case. The more detailed you are, the better you are protected. Not necessarily so. That's my point of view, personal point of view, because if you set it out in too detail, sometimes it's not easy to understand, and indeed you may tie the hands of judges when you start providing into detailed a provision. If you should leave this to the courts to give it the proper interpretation, it might even be better. But this is very it could be said more subjective than more a subjective view. But the fact is, Article 27 does contain 9 rights. 9 rights there. No elaboration, no examples. Right against torture is in a special category of general prohibition, and this is, and it says, the freedom of the persons of Hong Kong residents shall be inviolable. No Hong Kong resident shall be subjected to arbitrary or unlawful arrest, detention or imprisonment, arbitrary or unlawful search of the body of any resident, or deprivation or restriction of the freedom of the person shall be prohibited. So the first sentence, rather the second sentence, encapsulates most of the important rights. It says, no Hong Kong resident shall be subjected to arbitrary or unlawful arrest, detention or imprisonment, arbitrary or unlawful search of the body of any resident, or deprivation or restriction of the freedom of the person shall be prohibited. Torture of any resident, or arbitrary or unlawful deprivation of the life of any resident shall be prohibited. So that's Article 27. These are now I'm taking you to just a couple, of provisions where the protection is absolute. So torture absolutely prohibited under Article 28. This is about freedom of residence shall be inviolable, and no arbitrary or unlawful arrest, detention, imprisonment, and deprivation of freedom of movement, and specifically says torture is prohibited. So this is Article 28, and you will see this picture there, and the torture absolutely prohibited. That's right. It doesn't say that in emergency you can, that protection can be lifted. No, it can't, right? And Article 28 bans arbitrary or unlawful deprivation of life, right? So what's the word for it? Euphemism. People who want to commit suicide because of illness and so on is prohibited. Arbitrary or unlawful deprivation of life. Yeah. So following that, no torture. What about the rights? Article 33 states Hong Kong residents shall have the right, shall have the freedom of choice of occupation. And why is this in the Hong Kong Basic Law? Why is this in the Hong Kong Basic Law? Can you guess? I saw that some of you are typing, and that's why I'm holding my breath here to wait to see what ideas you have over. If not Hong Kong resident, they have no right, no freedom to choose their job. Yes? Yeah. That's right. I think what you said is correct. And again, to deal with the issue of confidence, then. And the article is very short, right? Article 33. It says Hong Kong residents shall have freedom of choice of occupation. And of course, we don't have the right to occupation, but the freedom of choice. Okay. Next slide. Right to go to court. Hong Kong residents shall have the right to confidential legal advice, access to the courts, choice of lawyers, for timely protection of their lawful rights and interests, or for representation in the courts. And to judicial remedies, Hong Kong residents shall have the right to institute legal proceedings in the courts against the effects of the executive authorities and their personnel. Right. This is, we just move on, right? We just move on to show you Article 35 about the right to court, and that includes the right to confidential legal advice. Well, Article 24 is a provision that sets out the qualifications for becoming Hong Kong residents. There's no requirement of nationality, so anybody could, if they happen to be holding a visa to stay, they may stay on. Yeah. The next slide I wanted to show you is another one that is not in the Basic Law Chapter 3, but Chapter 4. And it's 87.2, which provides that, let me see. Oh, I think, did I lose? Oh, 87.2. And anyone who is lawfully arrested shall have the right to a fair trial by the judicial organs without delay, and shall be presumed innocent until convicted by the judicial organs. Where are we? That's right. 87.2, right? Anyone who is lawfully arrested shall have the right to a fair trial by the judicial organs without delay, and he shall be presumed innocent until convicted by the judicial organs. The right to fair trial, right? The right to fair trial. What amounts to fair trial is not easy. In the code, this statement was put forward, which says anyone who is lawfully arrested shall have the right to a fair trial by the judicial organs without delay, and shall be presumed innocent until convicted by the judicial organs. All right. And the right to social welfare is a big subject. I mean, involves big money. Article 36 protects that right, and again, reference to in accordance with law. So, but in Kong Yun Ming, this is the person who went. Yeah, the Court of Final Appeal in the Kong Yun Ming case. This is the husband who came to Hong Kong with the wife and then did not have sufficient status to claim backup from the Social Welfare Department. The Court of Final Appeal used Article 145 to reject submission made socially to reject restrictions making social welfare less generous than system used before 1997. The next one, very interesting, about marriage. Article 37 protects freedom of marriage and right to raise a family freely. Let me look at that. Article 37. Oh, where are we? 37. Oh, over here. Freedom of marriage of Hong Kong residents and their right to raise a family freely shall be protected by law. Okay. Rights in the new territories. Article 40 protects lawful traditional rights and interests of the indigenous inhabitants of the new territories. It doesn't explain what are these rights, and it may include small house policy. Now, rights, it says lawful traditional rights, and they only applies to men and a minority of people in new territories. These are rights in the new territories. Small house policy is one. The other, don't know. Well, small house policy is this. It is not a policy which government must give land to descendants to build house. It is only when there is land available, and the land itself has to be controlled, and the land maybe in the village, and if you are indigenous descendant, then when you become an adult, there may be arrangements for you to become the landowner of a certain part of land on which you may build a house without having to comply with government building regulations. That's the small house policy. It's not exactly for government to give you land, but to allow you to build on this land to your own. Well, that's it. That is the so-called small house. Small being that when you look at the picture, these are small house because 3-story, and each floor is 700 square feet. Okay. Right. I just missed what you have typed out. They just Wujia is, if not Hong Kong resident, they have no freedom to choose their job. Well, the the way we say it will be that that person may not invoke the basic law, or may not invoke the Hong Kong Bill of Rights to redress this wrong or to compensate. You see here, you say no freedom to choose their job. Oh, no, they have freedom. They have freedom. The real question is, I thought a practical one, whether they are able to find a job at all. Okay. So that's the rights in the new territories. Any question on these rights? Okay. The next one, we are coming to Article 39. This is the provision in the article, in the article, and Article 39 bracket 1. Well, by the way, when we refer to bracket 1, it means the first paragraph. Bracket 2 means the second. This is a different editorial style. So, and indeed, when you are making reference to a Chinese text, the numbering system may not be adaptable. Okay, so 39.1 means first paragraph of 39. Who was it? So, Zhang Honman, we are now at 39. Right? The provisions, the wording goes this way. It's provisions of the ICCPR, the International Covenant on Economic, Social and Cultural Rights, and then International Labour Convention as applied to Hong Kong. It is not exactly these covenants that they may apply. It is only when the it's not that they apply directly, right? So there has to be law in Hong Kong for applying it, and that law we have seen is the Hong Kong Bill of Rights Ordinance, okay? And that's 39.1. So this will become having legal effect through laws, through Hong Kong laws. Why is Article 39.1 important? Well, let's look at these questions and for us. How many different human rights usually listed in each article of the Hong Kong Basic Law? Can somebody answer? How many different human rights are usually listed in different articles of the Hong Kong Basic Law? Article 27. What are these? Freedom of speech, of the press, publication, association, assembly, possession, demonstration, and so on. You said how many different human rights are listed in ICCPR? Look at Appendix 3 to Chapter 8. Appendix 3. Suddenly, okay, are we all right? Because of Article 39.1, almost all rights in ICCPR are incorporated into the Hong Kong Basic Law, and under Article 39.1, it gives special status to Bill of Rights, because that's also and here, as I had taken you there initially, and now just actually showing you the places where this double reference occur, but it doesn't change the substance. All right, Hong Kong Basic Law, we can identify 4 rights, and they are equality before the law, right to vote, freedom of speech, press and publication, and freedom of marriage. Okay. In ICCPR, as I said, or we noted that earlier, there was a lot of repetition. Now, equality before the law, this is the same. Right to vote is the same. Freedom of opinion and expression is on here. It refers to freedom of speech and also freedom of marriage. Then comes the right to marry, which in Hong Kong there is provision which goes to deal with young people, where they need their parents. If no parents, then legal guardian permission before they can marry. Yes, 9. So did you count? Okay, it doesn't matter. Okay. So are we saying that the basic law is not doing enough, or are we saying that too much is not going to help unless there is clear? Okay. Let me take you to the next one. Very short in the basic law, Article 26. This is about right to vote, standard election according to law. And on this is normally referred to as the public law rights. Every citizen shall have the right and the opportunity without any of the distinctions mentioned in Article 2 and without unreasonable restrictions, and to vote and to be elected at genuine periodic elections, which shall be by universal and equal suffrage, and shall be held by secret ballot, guaranteeing the free expression of the will of the electors. All right. So so next one, important. The details are important. Hong Kong basic law only says universal suffrage. This is Articles 45.2 and 68.2. But in the ICCPR, it's only mentioned once as universal and equal suffrage. Is this difference important? Not clear if this part of ICCPR applies to national elections. So, is this difference important, please? Article 25B, right? It says 25B says universal and equal suffrage, and Hong Kong Basic Law 42.2 only says universal suffrage. So are we already there? Now this is just for illustrating that when you get to the real thing, you will come across these situations where, maybe not too often, but you will come across this, and you really have to. Okay, Wu Jiayi, you're quite right. Equal needs to be interpreted. That's right, and of course, in an election law, this equal qualifies suffrage. It means the elaboration of it, the implementation of it. Right. Is this difference important? It's not clear if this part of ICCPR applies to local elections. Is this a difference important? Is it? The difference between universal suffrage and universal and equal suffrage? Well, to be honest, these really, the starting point is to give these the proper legal meaning through interpretation. Article 39.2 is also important because what it says is this: the rights and freedom enjoyed by Hong Kong residents shall not be restricted unless as prescribed by law. Such restrictions shall not contravene the provisions of the preceding paragraph of this article. And these are Article 39(1) and ICCPR as applied to Hong Kong. Now, the rights and freedoms, of course, we're talking about everything, therefore, and they are enjoyed by Hong Kong residents. We have, in the last few weeks, sent you sort of records about voters and registration, that sort of thing, and that is something which can be applied. I mean, to which this basic law may apply, or you may make it apply. And basically, it says that the rights and freedoms. So this will be the lot, the over 100 lot, enjoyed by Hong Kong residents, shall not be restricted unless as prescribed by law. So it really depends on how the magistrate sees his role. I would imagine the first thing that you will do is to get the magistrate to read it and not adopt it, but to show that they may be able to how do we say, and this is about unless prescribed by law part. All right. So first of all, it relates to everything in the basic law, which we know is plentiful, and shall not be restricted unless as prescribed by law is saying that these rights and freedoms may be restricted, but only by way of law or through law. And then it goes on to say such restrictions shall not contravene the provisions of the preceding paragraph of this article. Yeah, I was on this one. Here, just the reading of it, you should get the meaning that all these restrictions, I beg your pardon, all these provisions that relate to the exercise of rights could be restricted. But these restrictions, if they write them in, shall not contravene the provisions of the preceding paragraph of this article. The preceding paragraph of this article actually says about ICCPR and the other another covenant shall apply. Okay, and could read again. Prescribed by law, right? Rights and freedoms shall not be restricted unless as prescribed by law. What it means is when the restrictions are written into law, Article 39(2) recognizes this. Why is 39(2) important? Because it makes clear that most rights in the basic law can be restricted. It's only not torture. And it makes clear that any restrictions must pass several tests. What are these tests? Now, sometimes these tests are directly stated in the article, just like what I look at, right? So it's talking about restrictions already, and of course restricting, for example, right to whatever, then it will have to pass the test imposed by Article 39. some of these are stated in the articles, and these are restricted by law references. And most important test nowadays is the proportionality test developed by the courts. What are these? Let's look at these step by step. Has to be prescribed by law means the legality test. Not everyone to have law restricting rights. Law must also be adequately accessible and sufficiently precise. So Sam Gokse was complaining that the law was too vague. The law in relation to that conduct that he was convicted was too low. Laws which give wide powers to government may fail this test if not sufficiently precise about how government can use these powers. Well, how government will use these powers, when you look at the two bags, you will see. I was just on sufficiently precise, so and it is important because only then that people will know how to adjust their behavior and conduct. For laws that give wide powers to government, they may fail this test, and if they are sufficiently precise about how government use these powers. Let me take you through this again. Prescribed by law test. Why are we concerned about prescribed by law? Because it is a statutory criteria. It cannot be changed, or put it the other way, it can only be changed by those in the management role. The prescribed by law test came from the provision because it says it can only. Let me go back to the provision, right? Because it says prescribed by law, 39.2. This is what it says, unless as prescribed by law. So we say 39.2 was the initially, it was there that reference is made to it, and the courts later developed based on the interpretation of this phrase prescribed by law. And we can look at that ourselves as well. What is prescribed by law? The cases have developed since Sam Gokse, and it adds a little bit. It says it's not enough to have law restricting rights. Laws must also be adequately accessible, sufficiently precise, and okay. So just this point again, prescribed by law test came from the wording of Article 39, and it's not enough to have the law restricting rights. It has to be adequately accessible, sufficiently precise, and if they are too big a power, then that is where you have to be sufficiently precise. But how can, when you say sufficiently precise, language-wise, it means that you can never be, there's no scientific formula as to what is precise, but sufficiently precise, then it can be a test. Look the words that follow. So know how to comply with law. It's a little bit difficult to read. It may be better if it says, but does not need to be absolutely certain. I think that's the crux of it, and you don't have to therefore mention the whole what are we talking about? Not in every detail. Now, some Gokse refers to the offense of misconduct. Public officers breach. Misconduct in public office. Misconduct in public office. Misconduct in public office. At that time, Sean Gokse was complaining that it was so imprecise. It was not clear, and therefore he do not know how to protect himself at the cross-examination proceeding. The court quite sensibly basically says, well, there's nothing that we can say is absolutely certain. Nothing is absolutely certain. It's always a relative situation. So the complaint was not established. It was not accepted in the Song Gokse case. But then the accessibility, to take part in that program is very good. Okay, laws which gives wide power to government must fail this test if not sufficiently precise as how government can use these powers. We make reference to it in our JR, and this is where under the Public Order Ordinance, where the police commissioner was given some powers to regulate. Now this has to be stated in very precise or in sufficiently precise terms. If not, then the court may order these to be disposed of. And also, apart from the legality point about the legitimate aim, we should also look at again, back to 39.2, where reference to the words were not contravene. Now this requires interpretation. What does it mean by only allows restrictions which do not contravene? To start with, when you are arguing, when you try to understand whether the material can be the material that give the provision that gives the right can be relied upon, right? Let me put it the other way around. If there is a law or a decision, administrative decision made by government which restrict your right, then prima facie that is a breach of the basic law. Because if the basic law protects you the right, then if you act contrary to that, that obviously is a breach. However, majority of rights recognized or protected allows restrictions. Now this is where 39.2 again comes back, where you can look at 39.2 again. Let's look at the provision again. The rights and freedoms enjoyed by Hong Kong residents shall not be restricted unless as prescribed by law. That the way it's expressed, I think the message should be clear that shall not be restricted means when it's followed by unless. Reading together, it means these rights, and there are rights and freedoms which may be restricted, but only if such restriction is prescribed by law. A room for the interpretation is, or room for giving it a meaning is, you have to define what law means. Prescribed by law. Law meaning what? Prescribed meaning what? What does it mean by prescribed? Prescribed by law. And such restrictions shall not contravene the provisions of the preceding paragraph of this article. The preceding paragraph is actually as you remember, apply those rights set out there, and anticipating that there is a the restrictions cannot contravene the ICCPR. Preceding paragraph, preceding paragraph says ICCPR applies, right, through laws of Hong Kong, or in accordance with laws of Hong Kong. Right? So, prescribed by law test, and then this is where repeating, we look at the wording again. 39.2 allows, it doesn't say allows restriction, but the way it's expressed, you can reasonably argue that the drafters of the basic law recognize that there could be restrictions, and that's why they make provision that the restrictions have to be prescribed by law and has to be precise. And through there is what was described just now, the prescribed by law test or legality test. This is where you will go to the statute, go to the law, give it a reasonable interpretation, and then consider whether such a right has been given and whether there was a breach of those rights. In ICCPR, a few of the provisions there have the reasons for restricting some rights set out. You may describe that as legitimate purpose. Right? The courts now use these to judge restrictions under the Hong Kong Basic Law. If legitimate purposes listed in ICCPR, government must prove restriction necessary for one of these purposes. And you will lose if you cannot prove this. And sometimes this test is called necessity test. It's a bit confusing there. What does it mean, right? Sometimes that is called necessity test. This again has it's always because of the wording of the ICCPR. The necessity test basically involves a question whether imposing such restrictions on the people is necessary. Are there any less stringent means for restricting the rights of the people that the same legitimate purpose may be achieved? Are we using a sledgehammer to crack a nut? That will be a recipe, that will be a reason for failing the necessity test, because there will be other less restrictive means for adoption. So necessity test here, necessity test really means asking, it is merely asking the question, is it really necessary to have such a restriction on that human right? Can we not have some less stringent restriction in order to protect the same rights, in order to achieve the same legitimate purpose? Are we all right there? It may be a bit confusing, isn't it? It seems to be a bit confusing. But let's look at Article 19 and see how it may be applied. The exercise of rights of freedom of opinion and expression carries with it special duties and responsibilities. It may therefore be subject to certain restrictions. So, there may be restrictions in respect of freedom of opinion, freedom of expression. But there shall only be such necessary provided by law and are necessary. So, and it goes on to say, for respect of the rights or reputation of others, necessary for respecting others' rights and reputation, necessary for the protection of national security, public order, order public, or of public health or morals. So the various categories of interests are set out, basically everything, but not in a particular order, not that A becomes more important than B or vice versa. It's only for the government to consider if any new restrictions imposed, that whether that restriction is necessary for respecting somebody's rights and reputation, and for the protection of national security and so on, right? So that is ICCPR 19, and let's look at this. Limiting purposes for restricting rights. Legitimate purposes. Legitimate. First, rights and freedom or freedom reputation of others, national security, public order, order public, public health or moral, public safety. And we say 1 to 4 are legitimate purposes for restricting freedom of opinion, of expression, association, assembly, movement, and residence. That's from item 1 to 4. For item 5, is legitimate purpose for restricting freedom of association and freedom of assembly. What are the legitimate purposes for these restrictions? Law of defamation. What is the legitimate purpose for law of defamation? Why we cannot defame anybody? All right. Can somebody? Law of defamation. What is the legitimate purpose? No purpose? Yes, reputation of others. This is for protection. The purpose is for protecting their reputation, not to subject to unnecessary degrading remarks, which will cause the person's credibility or fame being adversely affected. So that's the purpose, law of defamation. And of course, it's very general when you say law of defamation. In Hong Kong, you have got the defamation ordinance, and there are different standards established for different contexts. And in this context, or here though, we are talking about, and because of that, it's a restriction over the freedom of expression. You cannot say things as freely as before because of these new restrictions. One of which is law of defamation, and we have just looked at it. And what about law protecting military secrets, such as the Official Secrets Ordinance? What will you think would be a legitimate purpose? Law protecting military secrets. Do we not protesting though? Wu I don't think it's protesting. Maybe you're Excuse me. I think you wanted to put down protecting. Yeah. Right. Okay. Yep. And law restricting street protests. What's the legitimate purpose? Yes. Yeah. Public order. You may even depending on situation, right? You may say public safety. Maybe if there's no maybe the street protests, they can grow big and cause obstruction to the thoroughfare. So that is something, that. So the public order ordinance imposed or set up certain mechanism for people to apply for organizing a possession, for example. Yeah. Quarantine law to stop spread of deadly disease. I think this question actually contains the answer that it's looking for, and that is stop spread of deadly disease, isn't it? Yeah. So public health. Law banning damage to Chinese national flag. How would you articulate that? Protecting what? What kind of purpose, legitimate purpose are there? What is the legitimate purpose for banning damage to Chinese national flag? Public moral, probably not. I would say the court in the national flag case did mention that it is the a legitimate purpose is to protect the integrity of the country, and it may also. It depends on how you frame it, how you say it. Yeah, upholding national dignity. Yeah, that's that, and people will not disagree. It seems to be quite a laudable purpose, quite a respectable purpose, and it could be applied as one of the legitimate purposes. Okay, and the next is about. Let's bring up a question here. What happens if there's nothing in ICCPR? ICCPR lists legitimate purposes for restricting rights, and these become the reasons for restricting the right, and you can't therefore manufacture some reasons because it's provided there. You can go outside it, so you in practice you must check the ICCPR. Some rights, though, do not have list of legitimate purposes for restriction, and in these situations, the court will have to consider. The courts will have to consider, and we put forward one situation here. What are unreasonable restrictions on right to vote under Article 25B? Article 25B. We can look at that. We can go there and see what it says. 25B of the ICCPR. It says to without every citizen shall have the right and opportunity, without any of the distinctions mentioned in Article 2, and without unreasonable restrictions, to vote and to be elected at genuine periodic elections. This shall be by universal and equal suffrage and shall be held by secret ballot, guaranteeing the free expression of the will of the electors. The question before you is what are those unreasonable restrictions on right to vote? Article 25B. The unreasonable restrictions. So if the restriction is about timing, there will only be 5 hours for everybody to cast their vote for the legislative council election. So time may be a restriction. How do you evaluate whether that measure is already is too much, or and to the extent that it is it breaches the Iccpr, or it infringes substantively, therefore, your right to vote, and a court can issue an order to quash your decision and so on. So timing is difficult to tell, isn't it? At the moment, the time is there is a set time, and I think the time is until 10:30 in the morning, in the afternoon, in the evening, and it may begin 7 something. All right, it has been adopted generally in Hong Kong. Suddenly, somebody in power decided to shorten the hours. Now, because of that, that becomes a restriction on the right to vote, and then the next question is whether that restriction or those restrictions are unreasonable. This is by way of applying an objective test. Proportionality test is more. We make reference to that in JR, and it is relatively more recent approach in assessing the lawfulness of certain government actions. But of course, this context, in our context here, although it actually overlaps, is looking at exercise of power from the basic law point of view, and in this basic law, protection of human rights in the basic law. The courts now use proportionality test to decide if restrictions on the rights may be allowed. This turned out to be, some described it as a constitutional review. It's growing very fast in recent years, and you will see that in the anti-mask law judicial review case, the provisions complained about are provisions in the subsidiary legislation, the prohibition against facial covering regulation, those provisions are subject to very rigorous proportionality test reviews conducted by Court of First Instance, Court of Appeal, and the Court of Final Appeal. It demonstrates quite clearly, I think, the approach adopted in relation to or in cases of either constitutional review or judicial review has become a norm, and in such that a way that different people may hold different views. CFI 2 judges, CA 3 judges, CFA 5 judges, and you can see that the 5 judges on the CFA, they are unanimous. They overturn the CA's decision on some of the provisions which they thought passed the proportionality test. And in relation to those that and in relation to CFI, the Court of First Instance, found let me see how to put it. Because you haven't really read if you have not read the regulation, it's difficult to appreciate what I'm saying. Well, the regulation, the anti-mask regulation is such that Section 3 applies to unlawful assemblies, unlawful processions. There are 2 other provisions which apply the same restriction, which are subject to the same restriction. They are actually lawful. They are actually lawful procession and lawful public assembly. CA Court of First Instance found that they failed the proportionality test, so as this Court of Appeal, but the Court of Final Appeal overturned the decision of the lower 2 courts below. Judges hold different views, so when you come to Mr. Zhang, you were very anxious about how to answer questions. There's no fixed, really model answer. You really have to argue the cases. Right? Although in our examination and especially now the assignment, we expect you to write essays on the topic more than solving problem type questions or scenarios in the problem type questions. We might, I'm not ruling that out, we might, because to be honest, that would be the best way to test how accurate the student actually had learned the concepts. They are very fast growing in this area and very important, but also complicated. Well, it's complicated, and yet if you know the facts well, then, as the Court of Final Appeal has said, it's very often a matter of common sense. So words are big, but the ideas are not that strange, not that unusual. Our first Chief Justice, Andrew Lee, had very succinctly described why we are using the proportionality test. He said that use of a proportionality principle in examining whether a restriction of a fundamental right is necessary in a democratic society is consistent with the approach to constitutional review in many jurisdictions. A proper balance is struck between the interests of society on the one hand and the individual's right. So you may be able to discern and to pick out from this statement that proportionality test is really a balancing act. It's a balancing act. In the context of a democratic society, people very often you have to adopt a give and take mindset. You can't win it all, and therefore the courts are tasked to look at these complaints whether there have been a proper balance have been struck. Now, proportionality test. At this part, I'm just going through it very superficially, right? We have this proportionality test has been described as sometimes described as a two-part test, sometimes three-part test, and more recently, in Hong Kong, we call it a four-part test. Originally, it's straightforward, two-part. You identify the legitimate aim, and then you look at the measure, and then you ask the question, is it a necessary measure? Right? If it's necessary, i.e. no better choice, then the restriction of the human rights will have to be accepted. We'll carry on. However, if it was found out that there are other means of achieving the same purpose and with less restriction on human rights, then this one may be held to be not valid. So for our purpose, we'll focus on the two-part version of the proportionality test. But it's good to learn what actually is the four-part test. First of all, you have to find the legitimate purpose for the restricting rights. And part one will have to show what is the real reason. Is there a rational connection, i.e. a logical connection between the restriction and the legitimate purpose? Well, in the case of Gong Yongming is a case in which a man over 70 years old, he married a mainland Hong Kong person. He went to mainland, married a wife very young. The wife came to Hong Kong to join him. About 2 years, the husband died, and because of that, she lost all the financial support. She went to Social Welfare Department to ask for Social Security, but under the policy then, she will have to satisfy the 7-year residence requirement before she can apply or get any social subsidy. The Court of Final Appeal ruled that government argued that it's necessary because there's legitimate purpose of saving money for the future aging population. But the court said, well, 7 years residence rule actually saves very little money, and so the court did not see that there was a rational connection between the legitimate purpose and the purpose and the aim, because there are less stringent means of achieving the same. Right? What the court said was this: the government is undoubtedly right to regard the problems of our aging population as serious and right to lay down policies aimed at mitigating those problems with a view to ensuring the long-term sustainability of our social welfare system. But what, if any, rational connection is there between such mitigation and the impinged policy of excluding new arrivals from receiving social assistance until they have resided here for 7 years? I do not think any such connection exists. So once the court did not find such connection, such a rational connection, then there's no need to ask the next test. The decision is simply will be found to be unlawful, not meeting the requirement of the law. So the part 2 test is, sometimes we use an expression, say minimum impairment test. Is there a better alternative? We always ask that question. Do we really have to adopt such stringent test, right? And that, of course, has the advantage of in public governance, the advantage of discipline, of good discipline for the government to think of all the possible alternatives, right? Remember, this also has a similarity. If you think back, we mentioned about Wensbury reasonableness. What is Wensbury reasonableness? And we brought in the concept that it actually the courts actually will not take over the role of the decision maker, but the court will consider if the decision maker had considered all options, of course reasonable options, right? And then the decision was made by relying on one of these options, right? And only if the decision actually went outside, beyond all that may be available, then the court may consider it will be is a defy of logic, and we described it as Wensbury unreasonable. Right. So we look at these judicial review cases very carefully. You can actually ultimately come down to one observation: nothing is absolute. It's always a balancing exercise. Right. So this is the how fundamental human rights are protected by judicial review proceedings, by the court applying the appropriate test, and by making the right orders. Now we've still got a few slides to go, which actually looking at the proportionality in more detail. But you do not have to worry about this. As we said, for proportionality test, we realize it's fairly complicated. So we ask you not to panic. Yeah. For those who are more concerned about the assignment, the 2-3 slides which we have on the Article 39 should be helpful. So please look at these, and you will see that the proportionality test was actually relied upon by the court for the purpose of interpreting Article 39(2), where there's room for the court to apply its judicial test, because it says such restrictions shall not contravene the provisions of the preceding paragraphs of this article. So how not contravene? This is the crux of it. So read this 39(2) very carefully, and when you're reading it, read back to 39(1), and you will see the relationship, and you will see how the courts have been developing these tests in order for the purpose of protecting human rights. Right, I'll stop here, and we'll meet again. We'll meet again next Tuesday, 12th. I beg your pardon, no. I've forgotten to. I will be asking the office to give us an alternative date for that because I will be busy 12 on the 12th. Yeah. Okay. Are there any questions? If not, then we'll call it a day. I realized I noticed that the temperature may have dropped or is dropping out there, and I don't know. Maybe for some of you who are at home and will continue to enjoy the warmness at home. I have to make my way from office, so it will be challenging. So, good night. I don't understand your question. I'm sorry. Jen Honman. I saw what you have typed, but I don't understand it. Don't worry.